Something else that was discussed at my meeting.
Are you muted?
Oh, I'm not muted.
Well, I'm not on mute. I looked at it. Okay, here, look over my shoulder. See, I don't see my picture on here. Okay. So this is Article 10. This may be another matter, but
That's fine.
okay,
We've got our first trial starting in about 2 weeks. And so we're trying to get our courtroom set up and talk about all the interesting things that we have to do, like an order that says that prospective witnesses can't watch the proceedings on YouTube live until they've testified and so forth. It's going to be interesting. Morning, Monica. And there's Wanda. I will get I don't know who's requested takedown. So in just a minute, I'll find out if anyone has.
Judge,
Yes.
Mr. Turnipseed for travelers did request a court reporter.
Oh, they have.
I'm just going to do it by the block it by the device, the iPhone. Is yours connected?
yes.
Why is mine not connected?
You won't come in.
Well, wait a minute. Now it might be.
All right. I may start a little bit early because I see I've got a lot of the folks here, and I wanted to take some of the shorter matters first. Actually, let me just sort of read through the cases and see who else might need a court reporter. Is there a court reporter request on Sidari versus Wyndham? Is there anyone here on that case yet? Okay. I know I had a request on Travelers. Is there a request for a court reporter on Courtney Johnson versus JMP Pizza?
Morning, Your Honor. Scott Harrison for the plaintiff. We don't need a court reporter.
Defense counsel? Maybe not here yet.
I'm the unnamed carrier, and we don't need it.
No
No.
takedown.
No, but I don't think the defense counsel may be here yet.
All right, I'll wait. It is a little early. And then on Dickerson, there are a lot of folks on this case, and I don't know if anyone who's here is requesting taking.
Your Honor, Bobby Anirku here for the plaintiff for the Dickerson matter. Good morning.
Good morning. Did you want takedown?
We don't need it, Your Honor.
Okay, and I don't know who's here for defense.
Well,
There are none.
Your Honor, we'll take the takedown.
Okay.
Good morning, Your Honor. It's Sharonda Barnes. I'm here for one of the defendants, Dr. Michelini, who's the motion is regarding. We requested takedown and Mia Smith is on to take it down for us.
Okay, thank you. So I've got at least, there are only 4 motions on the calendar, but it seems like most of them, well, at least half are requesting takedown. So when I start the case, I'll get an official announcement. I was just trying to get a feel for how many cases I was going to need a court reporter on. It's 9:58. I'm going to wait another 2 minutes before I get started to make sure I've got everyone here.
The computers out there,
They are not on. They're not,
they're not showing up.
no, I've got nobody here, but I don't show them. Now I can invite them now, but there's nobody here, right?
They were invited.
I know they were invited.
Let me go see, but maybe they could turn it off. Let me see.
Oh, I hope not. No, they're on.
Auto start in one, oh, it's an auto start in 1 minute.
Okay, good. So I guess you started it right at 10?
Yeah, I did it just to start when the hearing starts.
Okay, that's
Is
fine.
that fine?
Well, I think it's been suggested that we start them 10 to 15 minutes ahead of time. So
Oh, okay.
if there's a problem, we have enough time to contact,
I can do that.
okay, Shaniqua. So that's the only, all right, 1 more minute and we'll get started.
Good morning, Your Honor. This is Bowie Link. I'm representing Dr. Drayton and Dr. Drayton PC in the Dickerson matter.
Okay.
Your Honor, Russell Davis for the select defendants.
And Your Honor, this is Matt Coles. I'm also here on the Dickerson case. For some reason, I'm having a problem with my camera, but I don't intend to be speaking, but I wanted to let you know I was here listening.
Thank you. Yeah, I see you've got some sort of issue with that.
We're working at it at my end.
Hey, Judge.
Hey, I don't think you're supposed to be with us today. Are you on the
You don't
attorney's
have
fee matter?
18 EV 001278.
Oh, I
It was
do.
a contempt that was not served.
Oh, it was not?
I don't think so.
We had it down for attorney's fees
Return of service was filed.
for service on this. It was?
Sedona versus Wyndham.
Yes.
Yeah, served on the 26th of March.
We're showing it was served on March 26th.
Okay.
Are you ready to proceed or not?
Yes,
You need-
Judge. I mean, if the defendant's not there, then we've got the proposed orders for it.
Yeah, I think you were asking for $442.50 for an hour and a half. Let me find out, is Janet Wyndham here? Jeanette Wyndham. All right. So, and I don't know why these, let's see, I'm missing one of these. Hold on a minute. Just give me 1 second. That's the one I need to mute. Okay. All right, since that was going to be the first matter I was going to take. This is the case of Ali Sadari, Sardari versus Jeanette Wyndham, Windham, civil action number 18EV001278. And I'll be issuing an award of attorney's fees for $442.50.
Thank you, Judge. May I be excused?
Yes, thank you.
Have a good day.
I think that's fine. Okay, so now I've only got 3 matters left, and I think the majority of them want takedown. Let me go ahead and I think what I'm going to do is take the Dickerson case first because I actually have more attorneys are on that case. I don't expect this to take more than about 15 minutes. After that, I'm going to take the Travelers case, and then after that, the Courtney Johnson versus JM Pizza. And so those are the only motions remaining. So let's go ahead. This case did require takedown. It's Cynthia Dickerson. Oh, let me just state, first of all, good morning. My name is Diane Best, and I'm the judge presiding over this motions calendar. As I said, we've got 3 remaining motions. This virtual call is also being broadcast over our YouTube live station. I just wanted everyone to know if at any time anyone needs to have a private conversation with me or another attorney, certainly I can send you to a breakout room to have that conversation. This first matter is Cynthia Dickerson versus Wellstar Atlanta Medical, Regency Hospital, and let me just say et al. There are about 12 or so individual physicians and medical providers. This is a motion for summary judgment brought by 2 of the defendants, Dr. Mikkiläneni, and I'm sure I've not pronounced that right. And let me spell that, Mikkiläneni, and South Atlanta Pulmonary and Critical Care Associates, LLC. It's case number 19-EV004203. And who do I have here for the movants?
Good morning, Your Honor. My name is Devin Zacco, and I'm here along with Sharonda Barnes on behalf of Dr. Mikkiläneni and the practice.
Thank you. And then on behalf of plaintiff?
Bobby Aniku here for the plaintiff, Your Honor.
Just 1 minute. I know I have another, let me spell your last name for the court reporter. It's ANIEKWU. And I know I have a number of other individuals here. I don't know if they want their presence to be recorded on the transcript. If so, let me ask who else is here that would like their presence documented.
Good morning, Judge. My name is Kristen Malcolm. I'm with Huff Powell Bailey on behalf of Wellstar Atlanta Medical Center.
Thank you.
Morning, Your
Good
Honor.
morning,
Russell
Judge.
Davis for the Regency Select defendants.
And Bowie Link here for Joyce Drayton, MD, and practice.
And Your Honor, Matt Coles on behalf of Dr. Landrum, Dr. Mann, and Dr. Maduka.
And Maduka is MADUKA. And I don't know if it's Monica or Wanda doing takedown, but we can get you the full case site after today if you need some context in terms of spelling some of these names. All right, I have.
No, Judge, that's an outside court reporter taking us down. Thank you.
Oh, okay. All right. So I'm ready to hear from Movants. This is, I said, a motion for summary judgment as to these 2 defendants. Let me just state for the record, I have had a number of these on similar issues related to the skincare protocols for this patient and who is the plaintiff. And so I am familiar factually, but I understand that each side's making a record. And so certainly whatever you think is appropriate to do that in terms of this motion, you're welcome to do that. So I don't know, Miss Zacco, is that how you pronounce it?
Zacco, yes.
Zacco, or Miss Barnes, who's going to present, but I'm ready.
Okay, I'll just briefly go over then the facts in this case as they pertain to Dr. Mikkiläneni. As you know, Ms. Dickerson was admitted to Wellstar Atlanta Medical Center on August 9th of 2017, and she was admitted for difficulty with breathing due to her chronic COPD. Dr. Michelineni is a pulmonary and critical care doctor, and he saw her 7 times during her hospitalization at WellStar. He was providing care as a consulting pulmonologist to treat and evaluate her for her pulmonary problems and for her ventilator management. During her hospitalization, she developed pressure wounds. And the plaintiff alleges that Dr. Michelineni was negligent in his treatment, his management, and his care of Ms. Dickerson. Now, Georgia law is clear that the plaintiff's expert affiant must have regularly engaged in the active practice of the area of specialty in which the opinion is to be given, and have done so of sufficient frequency to establish the appropriate level of knowledge in rendering that treatment. The plaintiff's expert, Dr. Fadi, specializes in internal and geriatric medicine. And in his 133 paragraph amended affidavit, he does not simply state that Dr. Michelineni failed to perform a proper skin examination. Instead, he says that Dr. Michelineni, who's a pulmonologist, had responsibility for the entire patient's well-being, which includes skin, and that he breached the standard of care generally in his treatment and his management and his care of Ms. Dickerson. Therefore, the area of specialty at issue in this case is not skin management, but it's pulmonary consultations. And that sort of opinion necessarily requires that Dr. Fadi have experience providing pulmonary consultations in this context. We cite to a number of cases in our briefs. I just want to briefly focus on Dawson versus Leader and apply the plaintiff's rationale in this argument to that case. So there, the decedent suffered a respiratory arrest after surgery and died. The plaintiff brought a medical malpractice case against a defendant anesthesiologist who was present in the PACU after the decedent's surgery. And the plaintiff's expert stated that the defendant anesthesiologist breached the standard of care by failing to notify the attending physician of that decedent's airway management concerns and failing to transfer the patient's care to another qualified physician. The expert specialized in surgery and critical care, not anesthesiology, but the court recognized that she had an extensive and an impressive CV that showed that she provided care to numerous patients in the ICU. Even so, the court found that her general vague assertion that airway management and the risks of improper airway management fell within her area of expertise was insufficient. And the court denied, and so the court granted the defendant's motion for a summary judgment in that case. Applying the plaintiff's rationale here to Leader, all the plaintiff's expert would have had to say is that she's familiar that the standard of care for all doctors requires them to transfer a patient to a more qualified physician, and it requires all doctors, regardless of specialty, to discuss a decedent's airway management with their attending physician. And actually, that is the exact type of argument the plaintiff tried to make in Hope versus Crank. And I'm not sure this was cited to in the reply brief, so I'll give you the citation, which is 304 Georgia App 367 from 2010. And so there, the plaintiff realized who the defendant doctor in that case was a gynecologist. The plaintiff's expert specialized in geriatrics. And the plaintiff realized and conceded that his expert could not opine as to how a gynecologist could perform a surgery. So instead, he amended his argument to state that that his expert could opine that so many surgeries should not have taken place in such short of a time, and that the defendant doctor should have referred the plaintiff to another more qualified physician. And so those opinions sound very general, and they sound like something that would go across multiple medical specialties. But the court disagreed, and they stated that to permit even a veteran general practitioner to judge the performance of a specialist would eviscerate the very function and purpose of OCGA 24-7-702. And the purpose of that statute is to act as a gatekeeper against frivolous claims. And what we've seen here now is because the plaintiff is mischaracterizing this issue in this case as skin management, an expert specializing in geriatrics is providing a standard of care opinion, not just for the hospitalists, but for a pulmonologist, for a nephrologist, for a hematologist, and for an infectious disease doctor. And if Ms. Dickerson had, for whatever reason, required a neurosurgery consult during her hospitalization, Dr. Fadi would seemingly be authorized to provide an opinion as to how that consultation should have taken place as well. So I think it's important to note here that the issue is not skin examinations, it's pulmonary consultations. And Dr. Fadi has provided a very extensive affidavit, but nowhere does he state that he's a pulmonologist or that he's familiar with pulmonary consultations or how they should be performed. He is not even familiar with whether a pulmonologist has to perform a skin examination at all. The definition for a standard of care is not simply what a prudent physician would do, but it's what a physician in like surrounding circumstances and conditions would do. And Dr. Fadi has never found himself in the same surroundings or under the same conditions that Dr. Michelineni, a pulmonologist, found himself in this case when he was providing a consult to Ms. Dickerson's care. Now, Dr. Michelineni provided an affidavit in this case testifying as an expert that he met the standard of care and that none of his acts or omissions caused or contributed to Ms. Dickerson's pressure ulcers. The plaintiff has failed to provide any expert testimony of a qualified expert to render an opinion otherwise. And therefore, we ask that this court grant Dr. Michelineni's motion for summary judgment.
And, you know, I don't know, but I'll have to look at this case. What's the year on that case? Was it 2000?
Hope versus Crank?
304 Georgia Appeals.
Yes, that's 2010, Your Honor.
2010, okay.
What was the first case she cited? I didn't catch it.
The first case
She cited a case before that one.
what was the case that you cited before that you were discussing?
Yes, the first case was Dawson versus Leader. And I can give you this.
Yeah, I have that. That's 294 Georgia Appeals 717. Okay. Yeah, that was in the brief. The other one I didn't recall. You know, let me just say, and I'm going to hear from plaintiff on this. This is obviously not the first motion for summary judgment on similar grounds. The problem, and I haven't looked at this case, is so a lot of these are quite fact specific, which I think in just even by making that statement says these are questions of fact for a jury. I don't disagree that the affidavit submitted by Dr. Saba is generalized. I think there are going to be, I'm not going to be surprised if defendants present physicians that say, no, in terms of the pulmonologist, this was not within the scope of what his care should have been to examine a woman in this condition for bed sores. But the unfortunate, and I agree that the affidavit submitted by Dr. Saba is quite generalized. Has he been deposed?
No, Your Honor.
All right. And I don't know if he's going to be used as an expert in this case by plaintiffs. I mean, I guess he may not be, he may not be, but okay. Well, let me hear from plaintiff.
Good morning again, Your Honor.
Good morning.
Your Honor, this attempt to reconfigure or to pivot the case from what it should be to pulmonary treatment is simply a red herring. At no time did Dr. Saba appear to testify or indicate that he was testifying as a pulmonologist. But what he was clear about was that there are basics, just like in law school, when, you know, the first year everybody studies contracts, constitutional law, whatever, torts and all that. And the second year, you get to the next step, you know, the next stage of the same subject matter. Physical and skin assessment, Dr. Saba has testified, is one of those type of things where every doctor in a medical school, in training, in residency, they are taught to perform head to toe And in fact, in some hospitals, PAs and other non-physician, but people in medical area do perform skin assessment and physical assessments. And terostomal nurses and other kinds of nurses can also do that. So we're not talking about astrophysics here or anything. Now, let me first address the qualification issue. Dr. Saba is board certified in internal medicine. Dr. Michelinie is board certified in internal medicine. Pulmonology is the treatment of ailments of the lungs and respiratory system, such as asthma, pneumonia, tuberculosis, complicated chest infections, and COPD, chronic obstructive pulmonary diseases, including emphysema. That's all it is. And it is but a subspecialty of within the internal medicine. In fact, that specialty, designation is awarded by the American Board of Internal Medicine. So, but they're both internal medicine. Now, Dr. Saba, I've provided, yesterday I provided his CV again to the court as exhibit number 1. Dr. Michelinie, if you look at his CV on page 2, indicates that he had a postdoctoral fellowship at Johns Hopkins University at the Division of Pulmonary and Critical Care Medicine on Asthma and Allergy Center at the Asthma and Allergy Center on acute lung injuries. So it's not just that he is board certified in internal medicine, he's also familiar with the subject matter of pulmonary and critical care medicine. But that's not what he's opining about here. The issue before the court is the negligent performance of a skin assessment of a 300-pound lady that had numerous comorbidities. That's the issue. And what's telling in this whole thing is that on August 11th, a day after my client was admitted to the hospital, an intensive care unit, Dr. Michelinie, who had been her primary pulmonologist since 2013 or thereabouts, and was quite familiar with her medical history, her weight, her physical condition, her comorbidities, and plenty of other issues, medical issues. He was quite familiar with it. When she was admitted on August 10, he was one of the first people to consult her because that's what she went into the hospital for, COPD. Dr. Michelinie did not perform any skin exam, none is documented. The next day, August 12th, and they all laid out in his affidavit, restated affidavit. And I'll take a little issue with the statement that his affidavit is generalized. No, it is, like the court pointed out, very fact specific, fact intensive, but there's nothing generalized about it in the area that he's opining about. He indicated on paragraph 15 of his restated affidavit that no skin exam was documented. On paragraph 17, he opined that no skin exam, he did not see any skin exam except that Dr. Michelinie stated no bruises. What's no bruises? That means he looked at her, he tried to look at the body, but nothing there. August 13, again, he stated no bruises. August 17, no bruises. Then on August 24th, after the plaintiff had developed DTI and on August 19th. And on August 23rd, the wound care nurse stated that she had developed excoriated buttocks, a blister on the right posterior leg, a DTI on both the coccyx and left posterior heel, blister, and described the blisters as darkly pigmented with excessive moisture. All these are on the record. Dr. Micheloneni saw the plaintiff the following day, August 24th, and stated no bruises. How can that be? Either the wound care nurse that carefully documented all these findings on her skin was wrong, or that Micheloneni was wrong, or in fact did not look at her. The reason you see all those no bruises is that he did not bother to move or turn a 300-pound lady, because it was probably not worth his time. So then on 25th, he checked her again, and also no skin check was documented. And he checked her for 40 minutes, and no skin exam was documented. On paragraph 76 of his restated affidavit, he basically took everybody to medical school because he laid out in detail, which has been called generalized, but it's the factual basis, foundation for his opinion. He indicated a physical evaluation and assessment of patients, which includes skin assessment, is a subject matter that's well-trained and qualified physicians, including medical graduates, internists, residents, and attending practical physicians are taught very early in their medical careers. So he didn't say that that's something pulmonologists must know how to perform. And elsewhere, on paragraph 80, he indicated that a skin assessment captures the general physical condition of the patient at the beginning of the consult, based on careful inspection and palpation of the skin and documentation of the findings. You've got to take a look. What he's saying is that regardless of a consult, when you come, you got to look at the patient first, see what the status is, so you know where you're continuing to do your work, whether it's cardiology, whether it's pulmonary, whether it's critical, whatever. But you've got to determine what the status of the patient is at the beginning of your consult, and that's what was negligently performed here, or was not performed at all. Now, he also indicated that a thorough and appropriate physical assessment and examination, including head to toe exam, which he attached a schematic as an attachment to a schematic of it, as an attachment to his affidavit to support what he's saying, is that such head-to-toe examination of patients in the ICU and long-term care patient is mandatory requirement when rounding in the ICU and long-term care facilities, regardless of physician's area of specialty. That's paragraph 78 of his affidavit. I don't know how much more specific he can be. Unfortunately, defendant Micheloneni runs the issue framed as one for pulmonology. He did not carefully perform pulmonary consults. No, that's not what my client, Dr. Faba, is here for, and we have not argued that point. The point is that he failed. He failed in his primary duty to look at the status of the patient, see what's going on before continuing with and that standard of care, before continuing with his consult. The other thing is that they've indicated and they've cited distinguished distinguishable and non-related cases that don't have any type of relationship to the issues in this case. Geriatric doctor opining on what a gynecologist did, that's not related to this case. It's inapplicable. We're not opining on what Dr. Michelinetti did in the pulmonology space. Notwithstanding, he studied fellowship in pulmonary and critical care medicine anyway, and both are internal medicine physicians. They've been studying, so he's not totally unfamiliar with the subject matter at hand. And the rest of the issues, I think the court correctly addressed in the other similar summary judgment motions by other defendants. I'll just ask the court to take another look at paragraphs 15, 17, 18, 22, 28, 31, 76, 78, 79, 80, 88, 102, 110 of the restated affidavit of Dr. Saba. And in addition, I've submitted which we've submitted as exhibit number 2 for the court's, we filed it yesterday for the court's convenience. In addition, Dr. Michelinetti dodged the question whether he was an internist. He was asked in his admission request. He dodged the question where he was asked, admit that you're an internist by training. He says a pulmonologist. He was asked, admit that pulmonology is a medical subspecialty of internal medicine, and he dodged the question again and said he was pulmonologist. However, Dr. Ojioke, who was also a defendant before in this case, admitted in paragraphs 20 and 21 of admission requests that in fact, pulmonologist, that she was an internal medicine specialist, she was an internist, and that pulmonology was a medical subspecialty of internal medicine. We've submitted that as exhibit number 3, and we asked the court to take a look at paragraphs 20 and 21 of those admissions. For those reasons, we asked the court to deny the summary judgment motion, because the issue here is the treatment that was provided by the Dr. Michelinetti with regard to her skin assessment and physical assessment. We contend that it does not require any specialty. Anybody in medical field that I previously mentioned that is taught to do that. And also with regard to hospitalists, they said whether, that he was responsible for the entire treatment of the patient. The definition of a hospitalist is someone that's responsible for the entire care of the patient. However, I believe that Michelinetti indicated he was not a hospitalist. And that was something that was in the medical record previously. However, it makes no difference. The fact is, the facts that we laid out, his opinion, his testimony is that Dr. Saba failed to perform skin tests, and to the extent that he performed any, he stated no bruises at a time that my client the plaintiff had very large excoriated buttocks, blister on her right posterior leg, DTI on both.
Let me, now you're sort of going into, these points have already been made.
Okay.
But let me ask a question. So I'm looking at doctors, the recently filed affidavit from Dr. Saba, and it says it was filed January 2021. So this was filed after the motion?
It was a restated, an amended affidavit. Yeah, it was filed, I believe, I'm sorry, I don't quite.
Well, that's right. It was, you just filed it the other day, but the date of the affidavit is,
There's one on January 7th.
Yeah, my response to the motion was January 22nd.
okay. So there are several that have been filed. I guess I think the motion was filed based on the earlier affidavit submitted with the complaint?
No, Your Honor, basically what this restated amended affidavit did was consolidate Dr. Saba's initial affidavit, which had the same information, with his supplemental affidavit, which was filed sometime 2020, before the filing of the motion. So there's nothing new we're arguing here today that was not either in the supplemental affidavit and in his initial affidavit that were of record at the time they filed the motion.
Okay, well, we'll take a look at that. And let me just ask if defense counsel has a response.
Yes, hi, Judge Besson. I'm just going to try to be brief in terms of just addressing a couple of the things that he pointed out, and to clarify some of the points specifically as it relates.
And let me just state, if I can, for whoever's doing takedown, this is Miss Barnes.
Yes, sorry.
Okay, thank you.
This is Miss Barnes. First, as it relates to Dr. Saba's qualifications, what he started his fellowship training in is completely irrelevant to whether or not he is qualified as a pulmonologist. During the relevant time period in this case, in the 3 to 5 years preceding the care and treatment at issue, from 2012 to 2017, Dr. Saba was not practicing as a pulmonologist. And the nuance of our argument that I don't think plaintiff's counsel is appreciating is we are not saying that Dr. Saba is not qualified to talk about skin assessments. We are trying to say that the initial hurdle as whether a pulmonologist is even responsible for performing a head-to-toe skin assessment is required when they are consulted regarding ventilator management and lung issues.
And so let me, and as to that point, I'd written something down earlier that maybe this is the appropriate time, and I'm sorry to interrupt you.
No.
So I think there's a difference between desired protocol and what the standard of care is. And so I sense what you're saying. Yes, would at a best case scenario, would we like every physician that walked in to see a patient to conduct a full body assessment? Yes. Is that below the standard of care not to for someone in Dr. Michelinetti's protocol? You know, why the physician was called in this instance? I understand your argument. I'm still not sure if that's not a question of fact, but I certainly think that, I mean, I understand what you're saying.
Yeah, and to reiterate this, I've heard this articulated in similar motions that have been argued and in some of these appellate things that we've cited. If the court will indulge me in the analogy of a football team, that there's a quarterback and there's a receiver. Generally speaking, they are on the same team. They understand what each person's role is. But for the receiver to come in who has not stood in the shoes of the quarterback and say what the quarterback would, could, and should have done when they don't have the perspective, they didn't see the field as the quarterback did, it's unfair. It's unfair, and it's not, and that's the whole purpose of the gatekeeping rule requiring that they practice in the specialty, is so you don't have situations where someone who has not stood in the shoes, who has not been in a similar perspective and has not been in that situation in terms of decision making, is then making opinions about another person on the team. Yes, do they have a general understanding as to what each person's role is? Absolutely. But is a internist like Dr. Saba qualified to give an opinion about a pulmonologist? We just don't believe that that meets the criteria under the statute and under Daubert. quite frankly. So that's just the point that we wanted to make, and the nuance here that seems to not be appreciated is the fact that Dr. Saba has never been consulted as a pulmonologist, and therefore is unable to say what a pulmonologist in this situation should do and what their evaluation should entail. And that's the first hurdle that they have to overcome, which we don't believe they have.
Fiona?
Okay. Yes.
Quickly. At the end of the day, the record states that on August 23rd, the patient had all these injuries, excoriated buttocks and blister and all that. Dr. Saba stated that there were no bruises. The question then becomes, what was he looking at? Why was he even reporting there were no bruises? If it was not his job or his responsibility as a pulmonologist to do a skin exam or skin assessment, what was he reporting? What bruises? He said there was no bruises when a woman had a big sore on her buttocks that you could see her bone. You can see through all the way to her bone. Someone that was 300 pounds, so you got to go through a lot of flesh to get to the bone. And so on the 25th, after the nurse, the wound care nurse, indicated that those things were there, he said that there were no bruises. So that undercuts the whole argument that, well, we have to get past this first hurdle of what he's supposed to do. Well, he did what he was supposed to do. He negligently, well, I take that back. He did not do what he was supposed to do. He negligently assessed, even if he did at all. He didn't bother to assess the patient, and he just said no bruises. So they can't get over that.
Well, and so I understand where we're going on this. Okay. I'm obviously going to take this under advisement. I unfortunately am not been terribly persuaded that this is going to be a different result from the other similarly filed motions. It's not saying, obviously, that the case against all of these defendants is potentially going to be successful. But we're at summary judgment, and and let me just say, some of these opinions might change if there was a deposition of Dr. Saba. So I'm not really excited about revisiting some of these, but that might be something that might persuade me differently depending on what was said in his deposition. I don't know if he plans on, I don't know if he plans on being plaintiff's expert or not, but this is, I don't know how much discovery has or hasn't been done. I know we had obviously an emergency, judicial emergency for quite a period of time. It's a 2019 case. So you lost a year, but hopefully everyone's back up and running. And let me just also state, we're starting jury trials again, particularly civil cases. I'm starting one in 2 weeks. It's a 6-person jury, but we plan on gearing up for 12-person. We've made some modifications to the courtroom. We're in the process of doing that. But let me just say, for you folks, because this is I would call it a more complex medical malpractice case, if you anticipate that you want a special setting, I obviously don't anticipate that happening this year, but the sooner I get requests for those for 2022, we're going to start setting those this summer. So if you put a request into Ms. Abrams that you anticipate needing one, and maybe for the end of 2022, I suggest you talk about that because we're going to start getting a lot of them. Okay.
Thank you for your time.
Thank you all. Let me I know there were some other folks that were on this call. Did anyone else want to address the court before I release everyone on that case? Anyone else? Okay, great. Thank you.
Thank you, Anna.
The next case that I'm going to take is Travelers versus SRM Group. I think a court reporter was requested. It's case number 14 EV 001478. Unfortunately, I remember this trial, and it was quite a while ago, but the case had some appellate issues and recently came back to us first from the Supreme Court, and then I think the Court of Appeals made an adjustment to their earlier opinion. And so it is back with me on a final attempt for defendant SRM, who is seeking attorney's fees. It's a motion for attorney's fees, and my understanding, and it's based on the fees spent post-trial for anything related to the appeal. And let me just find out, who do I have here on this?
Good morning, Your Honor. This is Elizabeth Grady. I'm here for SRM Group, and it is my motion.
Okay. And Mr. Turnipseed, oh, you're muted, but I know you're here for,
Okay, Bill Turnipseed, how do you hear me now, Your Honor?
yes, I can. Thank you.
Thank you, Your Honor.
So Ms. Grady, I'm ready to go when you are.
Well, you're correct. We are here following the Supreme Court's recognition that your interpretation of a statute is correct. More importantly, that the Supreme Court's own interpretation was not. I guess this comes under the heading of no good deed goes unpunished, because now you're being asked to interpret that statute again on what I would submit is somewhat uncharted territory. I know you remember the case, but just to refresh your recollection as to some of the most important facts and procedure, SRM Group, my client, had refused to pay its workers' comp insurer, Travelers. Travelers sued SRM to recover the premium. SRM countersued, and it brought two claims. The first was for bad faith. SRM was saying, look, the reason we didn't pay the premium is because you, Travelers, conducted yourself in very bad faith in how you handled this contract. It's a quasi-tortious claim. And in conjunction with that claim, SRM also asked for its litigation expenses pursuant to Section 13611. Now, the language of that statute is important, so I think it's good, and it's very brief. It's good for me to just recap. 13611 states, the expenses of litigation generally shall not be allowed as a part of the damages, but where the plaintiff has specially pleaded and has made prayer therefore, and where the defendant has acted in bad faith, has been stubbornly litigious, or has caused the plaintiff unnecessary trouble and expense, the jury may allow them. Now, I was not involved in this case below. I became involved because of various pieces of litigation that arose out of SRM Group's issues with having insurance, including the Travelers' cancellation of its insurance. That sprawled outward quite a bit. And so I had to read the transcripts to know what happened. And certainly counsel for both sides were excellent. They did a great job. But what told me what happened with the jury was when I read the testimony of Travelers. And I could understand from Travelers' own testimony and account of events why the jury said this insurer acted in bad faith, and we're going to enter a verdict of bad faith against this insurer. And alongside that, we're going to allow attorney's fees. We're going to take this case outside the general rule of parties bear their own fees. We're going to allow SRM Group to recover its attorney's fees because of that bad faith. Now, this is exactly what 13611 contemplated. It contemplated a situation where we're not talking, and maybe it also covers that, but we're not really talking about what Travelers did during the lawsuit. We're not talking about a 9, 15, 14 type situation. We're talking about the party, how it behaved toward SRM Group, how Travelers behaved before a lawsuit was ever filed, was in such bad faith that the jury entered a verdict for SRM Group on that claim. And the fees come with it. And it's not about parsing. Was it this motion that was wrong? It's not anything that council did. It is what the party did. Now, following the trial, Travelers made some post-trial motions attempting to undo that portion of the verdict. Actually, more than one thing, but at any rate, these were denied, and you upheld the jury's will and award, and then Travelers appealed. This is actually the point where I became involved in the case, because by then I was handling SRM Group's litigation that followed these events and arose out of them, at least in part. Travelers appealed. When I saw, at first I thought, well, why would there even be an appeal? But because I read the statute, I read the language, it says pretty clearly, SRM specially pleaded and prayed for its attorney's fees, litigation expenses, because Travelers acted in bad faith. We're good. But Travelers pointed out some Court of Appeals cases where the Court of Appeals, for whatever reason, had carved out an exception to 13.611. The Court of Appeals said, well, yes, a plaintiff can seek fees for bad faith, but a counterclaim plaintiff cannot. It really did not make any sense. And I think it started with some kind of initial error that kind of and the law just got a little bit tangled. A federal court had already weighed in and said, Georgia law is just kind of taking a curve here from its own cases. But at some point, that became the black letter law, according to the Court of Appeals. And needless to say, the Court of Appeals reversed. They reversed the order you had entered, saying that the jury could allow SRM Group to have its litigation expenses, even though SRM Group was a counterclaimant. We felt that was just, even though it followed the case law, we felt that it did not follow the statute, and we decided we had to go up to the Supreme Court and seek certiorari. That was not going to be an easy battle, we felt, because the Supreme Court had at some point adopted the Court of Appeals view without really commenting on it. So I was in the unenviable position of going in to the Supreme Court and saying, you were wrong. The Court of Appeals is wrong. The jury was right, and the judge was right in seeing that. But the statutory language was it was clear. And in fact, the Supreme Court saw it the same way. Despite Mr. Turnipseed, repeatedly citing the Supreme Court's own cases to it, the Supreme Court said, well, what matters is not what we said before, but whether or not we were right. Did we interpret the statute correctly? And it appears we did not. And so we're going to reverse the Court of Appeals. And that brings us back to where we are. Now, what happened along the way was, and I can't say it occurred to me because it's not my money, but my client said, well, okay, what about all the litigation expenses we have from the post-trial effort, and then these appeals and the oral argument? And I looked at the statute, and I don't see anything in the statute that says once the jury has allowed the party to recover its litigation expenses, that stops. I don't see a differentiation between pre-trial and post-trial. It seems to me that the jury gets to decide entitlement according to this. Now, the only question could be the amount, because if fees are incurred after the jury has gone home, well, but courts frequently and typically bifurcate entitlement from amount. So that did not seem to be an issue. And at any rate, it just plainly under the statute, the jury could and did say that SRM Group is allowed to recover its litigation expenses, and the Supreme Court has said the jury was right. So we're here. I will say that at that point, I did have some concern. I had not raised it with the Court on Appeal because it had not come up below. The fees had not been yet sought for post-trial effort. And what I hoped to do was get some guidance from the Supreme Court. So I filed a motion for clarification aimed at getting them to say one way or the other, because I knew this would be an issue. What about post-trial fees? I felt that if I didn't raise it, then Mr. Turnipseed might even, in an abundance of thoroughness, say I had waived it. So I raised it, but I did not really expect the Supreme Court to rule on it because it was an evidentiary issue, and just an issue that had not been raised below. So the Supreme Court is sitting as a reviewing court. It has nothing to review at this point because you haven't passed on the question of what and whether the fees are continuing after trial. Now, I will say that I think we have a very simple statute and the language is clear, but we also have a lack of precedent. So that is why I filed the motion the way that I did and asked for a ruling on entitlement before we get into amount, which will be a separate evidentiary question. Now, last night, Mr. Turnipseed served a supplemental brief, which I have not had a lot of time to look at, but what I will say is his supplemental brief, he's relying on the argument of law of the case, which, it would certainly be great if there was a magic bullet for them, I'm sure, but it just simply is not that, because this is not a law of the case situation. And I think the first indication for you that this is not a law of the case situation is if Mr. Turnipseed had a ruling from the Georgia Supreme Court saying SRM Group is not entitled to its attorney's fees, he would have attached it to the supplemental brief. He did not, because there is no such ruling. We filed a motion for clarification, hoping that the Supreme Court would venture in and give us some guidance on post-trial fees, but it did not. But I would tell you, because it had not been an issue brought to you and it wasn't able to review it. But at any rate, the motion I filed, there is an order on it, and this is what the order says. It says, upon consideration of the motion to clarify filed in this case, it is ordered that it be hereby denied. That one sentence is the entirety of what Mr. Turnipseed is basing his law of the case argument on. That is the only thing that order says, is that the Supreme Court would not clarify its ruling. It does not say the SRM Group is cut off from seeking attorney's fees. One reason the Supreme Court, I think, would not even view it that way if it were presented with this view that Mr. Turnipseed has of the law of the case, is that law of the case does not apply if the evidentiary posture has changed in any way since the appeal. And one of the many cases that says that is Cancel, C-A-N-C-E-L, the Medical Center of Central Georgia, 345 Georgia Appeals 215. This is just not a situation where the Supreme Court has said anything about this issue. And one reason it didn't and wouldn't is because it's a new evidentiary issue, or at least a new record issue, because it had not ever been presented to you below. So I just think that argument, law of the case, does not get us anywhere. Where we are is SRM Group has a judgment against travelers for bad faith. And that judgment includes a verdict in SRM Group's favor on its claim, its separate claim under section 13611 for litigation expenses. The jury has already said SRM Group gets those. The only question we have is, what is the amount? And the jury can't say that, but the jury doesn't have to say that. That is something courts frequently and typically do. And that is what we should be doing at this point. We should have a summary judgment type procedure where we submit our evidence of what the post-trial fees paid were. And if Mr. Turnipseed wants to argue that these were not paid, then, you know, he can do that. I mean, he can make any other legal arguments that he wants to make, but I think there would be a real tendency to get into a 9, 15, 14 argument where, well, the motion was well-founded or the Court of Appeals agreed, but that's not the question here. The question is, does SRM Group have a verdict saying Travelers acted in bad faith? And in connection with that verdict, did the jury say we're tossing out the general rule of each party bearing its own fees? SRM Group is entitled to recover its litigation expenses from Travelers.
So let me ask, if I look at 13.611 and it says where the plaintiff has, you know, expenses of litigation generally, and then it says where a defendant has acted in bad faith, been stubbornly litigious, or caused unnecessary trouble and expense. So these, you would have to demonstrate to me, and I'm not saying I'm in agreement that 13.611 is ever appropriate for post-trial or post-judgment fees. But let's just say I'm interested in discussing this with you because this is the sort of the basis of your motion. To get fees post-trial, you would have to show that you were caused unnecessary trouble and expense, been stubbornly litigious, or that the other side acted in bad faith post-trial. And the difficulty I have in accepting any of that is the fact that when they went to the Court of Appeals, the Court of Appeals said, you know, the underlying court, the trial court, was wrong. Now, I realize the Supreme Court and did that based on a number of years of precedent, and then the Supreme Court reversed. But it would sure seem to me that their behavior post-trial would not fall in any of these categories: bad faith, stubbornly litigious, or unnecessary trouble and expense.
Well, so we're not saying that we're seeking fees based on their post-trial behavior. We're saying that 13.611 is a different kind of fee provision than 9, 15, 14. It is not about the litigation, or maybe it can be, but in our case, what the jury decided was that 13.611 applies not based on how litigation was conducted, but based on Travelers' conduct before litigation. In other words,
but you've already been compensated for that.
No, our argument is that we have not been, because the way 13.611 operates is if the defendant acted in bad faith, then all of the litigation that happens after that is a result of that, whether or not the litigation is handled improperly or not. We would not.
But under that thinking, we would never let a jury go, because there could be anything subsequent that I might have to call them back and say, oh, we need another ruling now because someone else has incurred additional expenses. I mean, I'm just really having a hard time understanding and agreeing with your but thoughts on this. And I'm going to give Mr. Turnipseed obviously a chance to, he's been patiently sitting, and I'm sure he's got some things to address, but the argument you're making is, to me, it is really difficult for me to in any way be able to award you fees on this post trial. And I think you, again, already been compensated for everything that happened prior to that. That's what the jury awarded. And I don't anywhere see anything that says that 13.611 provides you with an opportunity to get attorney's fees post judgment or for appellate work. But let me just ask Mr. Turnipseed if he'd like to address your arguments.
Thank you, Your Honor. How do you hear me?
Yes, sir.
Okay, thank you. Couple of things, Your Honor, and I won't take much of Your Honor's time. I know you've got people behind us. Counsel said that we're in uncharted territory. Well, I think our briefs, and we filed two, one on February 9th of 2021 in response to this motion for appellate attorney's fees, and we filed a short 4-page supplemental brief yesterday. And I'm glad Ms. Grady got her copy. I've had some difficulty emailing her. At least I attempted to email her a copy, so I'm glad she got it. There are two reasons why this motion ought to be denied. First, we contend that the law of the case as manifested in the Supreme Court's order dated May 18th, 2020, denying what Ms. Grady calls as a motion for clarification. We contend, Your Honor, that should be the law of the case under OCGA section 9-11-60, parent little h, closed parent period. And that provides as follows, that any ruling by the Supreme Court in a case shall be binding in it and all subsequent proceedings in that case in the lower court. Now, Ms. Grady has represented that the motion that she filed on behalf of SRM in the Supreme Court was a motion for clarification. And the operative word is clarification. If you look at that motion, a copy of which is attached as Exhibit 2 to the Travelers February 9, 2021 brief, it's plainly an order. It's plainly a motion seeking an order regarding SRM's appellate attorney's fees. And in the last paragraph of that motion, counsel on behalf of SRM, seeks an order. In fact, it states in the conclusion on page 11 of this motion filed in the Supreme Court, and this is Exhibit 2 to our initial brief, Petitioner SRM Group respectfully requests that the court direct the trial court to hold an evidentiary hearing as to the amount of post-trial and appellate litigation expenses the petitioner is to recover. Well, that motion was denied. Now, the Supreme Court can call it the motion for clarification is denied, but it's obvious that there were only two motions filed in the Supreme Court, one by SRM seeking its appellate attorney's fees, and one by Travelers, which sought Rule 6 sanctions for SRM having filed such a frivolous motion. Both of those motions were denied, and we've attached copies of both orders in our proceedings. But the bottom line, Your Honor, on this is that it's clear that the law of the case in this case is manifested in the Supreme Court's May 18th, 2020 order denying SRM's request, motion, call it what you will, for its appellate expenses. Secondly, we would ask the court to deny this motion before the court in as much as this is not a, as Ms. Grady has stated, an issue which is in quote uncharted territory, close quote, period. It's clear in the decisions of David Brown and in Caldwell v. Church, both of which were cited in our brief, that this issue has already been resolved both by the Supreme Court of Georgia and also followed by the Court of Appeals. As cited in our brief, Your Honor, the late Justice Hines ruled in David Brown, and that's at 276 Georgia 849 850-51 2002 decision, that 13611 does not authorize a party to recover its post-trial and appellate legal expenses, even if a jury has awarded them in the underlying case for bad faith. Now, that decision was followed most recently in the Court of Appeals decision of Caldwell v. Church, 353 Georgia Appeals, 141, 149. So in a nutshell, Your Honor, we contend that the SRM motion pending before the court should be denied for two reasons. One, it's barred by the law of the case under 91160H. And secondly, that 13-6-11 has already been determined not to provide for post-trial and appellate attorney expenses and attorney fees and expenses in the decisions of David Brown and in Caldwell v. Church. And for that reason, we would ask the court to deny.
Thank you. Did you want to briefly, Ms. Grady, make a response?
Well, briefly, I think the law of the case is a red herring issue. The motion that I made is what the Supreme Court says it is. And the Supreme Court called it a motion for clarification. The Supreme Court knows a motion for fees when it sees one, and it saw Travelers' motion for fees and expressly denied fees, whereas it denied me clarification. Now, turning to the more important discussion is, what does Section 13-611 provide for, and what does the case law say? Well, Mr. Turnipseed relies on Caldwell v. Church, but in that case, the jury awarded the plaintiff all of his fees, which happened to include litigation expenses incurred during an interlocutory appeal. So it certainly did award fees, and it just didn't discuss whether or not they were separate. And what I think is actually the most important issue here is David G. Brown, and no case that I've seen deals with our particular case. Our particular case, we're traveling under a statute that has three separate grounds for attorney's fees, and ours is for bad faith. And we have a judgment that Travelers acted in bad faith, and we're not talking about in the litigation. We mean in how it handled the entire dispute and enforcing SRM Group to litigate to resolve it. In other words, SRM Group never should have had to come to court over this dispute. And because it did, under 13-611, SRM is entitled to all of the resulting litigation expenses, and nothing takes appellate or post-trial expenses out of that, because the only question, and I understand your point about the jury has gone home, but the jury can go home because it's already decided the only question that matters. And that is, did Travelers act in such bad faith toward SRM Group so that SRM Group was forced to sue Travelers, causing SRM Group to be rightfully entitled to recover all of its litigation expenses? That is the question here. And the jury already decided it. You know, the jury decided Travelers' bad faith, and the question of more amount is not one it needs to decide. That's something the court can decide. But the jury decided Travelers engaged in bad faith, forced SRM Group into litigation, and now litigation expenses is an item of damages that SRM Group is entitled to recover. The amount has increased, but the entitlement has not changed. It's based on what already occurred and what the jury already decided.
Okay, thank you. So, and let me just say, I'm clearly sympathetic to SRM's such dilemma here, because at the end of the trial, both sides were awarded a certain amount of money, and it was obvious that what the jury was saying was, we think that not only did, I think in some respect, they held both sides somewhat responsible, and it's obvious because the amounts awarded split the difference exactly, and neither side was technically it was financially going to benefit from the litigation. And so to then have to withstand sort of the appeal from travelers and spend more money. I'm obviously sympathetic to that, to now find out that the original award was in fact appropriate. But that having been said, I'm really doubtful that I'm buying into the argument that SRM is entitled to more fees. To me, 13,611 is pretty, it's been pretty well established that post-judgment fees are not included in that. I think, again, the fact that there was a disagreement between the Court of Appeals and then the reversal by the Supreme Court demonstrates that there was actually a legal issue here that needed to be resolved. And so if in my mind, SRM was in fact compensated for all alleged bad behavior in the underlying suit, but then anything going forward, is there evidence of bad faith or being stubbornly litigious? And I understand your argument, but I'm really reluctant to award you fees on this. But I'll take a look at everything and issue a ruling shortly. Thank you all for your patience, and you're free to go.
Thank you, Your Honor.
Thank you.
Thank you. All right, the last matter, is there a request for takedown on Courtney Johnson versus JMP Pizza? I wasn't quite sure who's here on that.
Good morning, Your Honor. I'm Scott Harrison on behalf of the plaintiff, and we are not requesting takedown, but if anyone else wants it, I will share in the cost.
Your Honor, this is Parker Lavin on behalf of JMP Pizza, and I echo Mr. Harrison. We are not requesting a takedown.
Okay. And the third gentleman who's here, Mr. Alsabrook?
Yeah, the unnamed defendant, USAA, does not need takedown.
Okay, so Monica and I forgot who else was here, but y'all are free to go. Thank you.
Okay, thank you. Thank you, Judge.
All right. So let's go ahead and let me just state for the record of our informal record, this is Courtney Johnson versus JMP Pizza Inc. and Nicholas McCall Easterling, case number 20 EV 007074. And this is JMP's motion to set aside an open default. And I apologize that you had to listen to that medical malpractice case, which is now the fifth motion I've gotten on the same subject, Amy? Yes. At any rate. Okay, so Mr. Lavin, are you here to?
Yes, Your Honor.
Okay, thank you.
I will proceed, and I apologize. I'm in a hotel room with the worst lighting, so apologies for that.
Well, we never have good lighting here in the courtroom. I need some extra mood lighting. There we go. Okay.
Well, Your Honor, we are here on JMP Pizza's motion to set aside the default judgment and open the default for a number of different reasons and grounds. The first being that JMP Pizza's position is that service was not properly affected. And given plaintiffs disputing that, at worst, this is a factual dispute at this point as to the service. Also because the motion was made during the same term during which the default was entered. It is within the court's discretion. And also there is good cause and that the ends of justice would be best served by opening this default. There would also be no prejudice to plaintiff in opening this default at this time. In this case, a preservation letter was sent. There was a motor vehicle accident involving the plaintiff and the co-defendant, Mr. Easterling. JMP Pizza is Mr. Easterling's employer through a Domino's Pizza restaurant. And there was a motor vehicle accident in November of 2020. On November 27th of 2020, JMP Pizza received a preservation letter from Mr. Harrison indicating a potential case would be forthcoming, and they promptly forwarded that to their insurance carrier, Cincinnati. At that point, they were waiting to see if a lawsuit would be filed, and they had not received one. They did receive in December of 2020 through a process server what they believed to be another copy of that preservation letter. And that was, set aside. They'd already received that. Mr. Harrison and his process server contend that that was actually a copy of the complaint. But my clients understood that to be another copy of that preservation letter. Thereafter, the time to respond to that complaint that was filed in December of 2020 passed. And just after the 15 days to automatically reopen that, Mr. Harrison reached out to my client at JMP Pizza and offered to, if they would accept service and that the proper entity was named to set aside that default and move forward with the case on the merits along with the co-defendant. At that point, I was brought in here as my client, was not aware that there had been a default, and we promptly filed a motion to set aside that default. And so we believe because there is the proper service was not affected here, that under 9/11/60, that the default judgment is not valid at this point. But also, even if it was valid, and even if that factual dispute was resolved, that this is within the inherent power of the court. It was filed during the same term, which brings it within the discretion of Your Honor. There are meritorious defenses that my client, JMP Pizza, has in this litigation. And if the default judgment is vacated, we ask that the court open the default pursuant to 9/11/55, as all of the preconditions are met here. And also there is, there are arguments of excusable neglect, which is a fact issue here, but also that this is a proper case. And under the Supreme Court's recent ruling in Bowen v. Savoy 308 Georgia 204, that the proper case standard is a very broad standard, and one of the big issues is whether the plaintiff will be harmed or prejudiced by opening the default as a universally pertinent consideration. And here, where there has been no discovery, depositions have been put on hold pending resolution of this, where the plaintiff itself offered to set aside the default shortly after the default was done, that there would be no prejudice here. So therefore, we ask that you set aside the default judgment and open this case.
And I do have a question that's just something I wrote down and I didn't really, I'm looking at the certificate of service on one of Mr. Easterling's answer, and it says on January 12th that it was, I guess, I don't know if it was served through e-file or deposited in the mail. Do you know if your client received that?
The certificate of service from Mr. Easterling?
Well, the filing of the answer.
My client did not receive that.
Okay, because I'm just saying on the certificate of service for that, which was sort of a month before, was about 6 weeks before you filed your motion to set aside. It says here under the certificate of service that they basically mailed it to JMP Pizza on Fairburn address. I mean, and the only reason I'm asking that, I mean, there's a question about when, in fact, your client had notice of the pending lawsuit. And even if he wasn't aware of it back, or, when it was served, did he in fact receive a copy of co-defendant's answer?
Their address had changed, and that the original process server that attempted to file the complaint back in December had gone to one address and then had reached out to, someone had called my client at where their address was, and then he went there. And so that letter, my client has stated that they did not receive any answer to this, and they'd not been aware that a lawsuit had been filed. And in fact, they had had numerous discussions with their insurance carrier, Cincinnati, during this time, saying, hey, has the complaint been filed? Where are things? They said, we're still waiting here. I mean, this is a process they've been through before, as far as if they get a complaint, they tender it to their insurance carrier, and that's typically how it gets handled. But they had not been aware of this until Mr. Harrison called my client on February 4th and said a default had been entered, motion for default had been entered, and that they would be willing to set aside that default if they would accept service. And at that point is when I was brought in here.
Okay, thank you. Thanks for answering that. Okay. Mr. Harrison, did you want to respond?
Just briefly, I would like to make clear that when I talk about intentional deceit, I'm talking about the clients and not the involved lawyers. What really happened is JMP Pizza stands for Joseph M. Podson. He was the registered agent and is believed to be the CEO. When I went to file the suit, there was an address for the registered agent, Joseph M. Podson, on behalf of JMP Pizza. That was some residential address. So that's where we sent the process server in the beginning. He gets there, and as it turns out, that's apparently a house that Joseph M. Podson perhaps used to live in, but now rents out to someone else. And so the process server, not being a rookie, is not going to leave the paperwork with a random person who's not the registered agent that's at the address listed on the Secretary of State's website. But that's the reason JMP Pizza is saying their address changed, because at the time of filing the suit, the quote unquote incorrect address is the address they had designated with the Secretary of State for service on the registered agent.
And is that the Fairburn address, or is that the Roosevelt Highway? I don't know if that matters, I guess, but.
It is the address that's going, I'm gonna have to look that up to get you an answer.
Okay.
It's gonna be the one that's listed in the original 5.2 that was filed with the court, will be that address. So it is.
I believe that's the Fairburn one was the original one, and then the Roosevelt Highway was where Mr. Podson actually was.
So the address that's in the original Rule 5.2 that I pulled off the Secretary of State's website that was listed for the registered agent is 4092 Old Glen Cove in Fairburn. I'm sorry, Parker, if that's what you just said. I didn't mean to restate.
No, go right ahead.
Okay, and that's on your original certificate of service. Go ahead.
And to be clear, I think it's a miscommunication, but I didn't offer to withdraw default if they agreed to those things. I put in my affidavit that when I called, it was my intent to do that. We never had that conversation because frankly, I got upset at what I believe to be basically an obviously false response. When they started saying, first, we didn't get anything, and then second, the story changed to, we got some stuff, but not properly served because you left it at an old rental house, and finally to, okay, fine, you served the CEO at his office, but you served him with the wrong paperwork. That's when I never made that offer to them, but it was my intent to do that. That's what I typically would do in that situation. And I agree the court has broad discretion, and I think that's why none of us are bothering to having this taken down. The court can decide what a proper case is and what's not, and that discretion is nearly unlimited. I think it's not a proper case because, you know, I think the rules of professional conduct require me to assume in the beginning of a lawsuit that the involved parties are going to do the right thing and answer questions honestly when they're under oath, etc. But when I've been presented with evidence in the beginning of a lawsuit that that's not likely to happen, I don't think I'm required to assume the best of those corporate defendants anymore when they've shown that they're not going to tell the truth in the discovery in this case.
Okay, and is this, I'm sorry, I looked at this last week, and is this the response from the defendant partially that we got papers, but I thought it was what we'd already received, the demand, and we didn't realize it was an actual lawsuit? Am I correct on that?
Yes.
Okay. I thought that was it, but I wanted to be sure. Okay.
It's
Sorry,
in
anything
response-
Yeah, go ahead, Mr.
Your
Levin.
Honor, the only additional comment I'd make, and, you know, I understand Mr. Harrison was upset and, you know, felt that the, you know, defendants were, you know, questioning the, you know, truthfulness of his process server. And I don't believe that was the intent here at all. I believe that the, you at worst, this was a good faith misunderstanding on their part, assuming that Mr. Harrison is correct and that the complaint was in those papers, that, they did not completely understand that. I think that is the worst case here. I think, their argument that this was, it was the same letter. To be honest, I don't have a copy of, they don't have it anymore, so I'm not sure exactly what it was, but I think at worst it was a misunderstanding, and that, the standard here and the discretion within your court's, power, would make this a proper case for opening the default.
Okay. Well, I'll take this under advisement, and I've been through most of it, but I always want to talk about it again after our oral argument with my staff attorney, so I'll do that. Is Mr. Let's see, Alsobrook, did you have anything you wanted to address to the court?
We would agree with JMP Pizza's position in this, obviously. And we think that we're so early on in this process, and the facts, we think at best, are convoluted, not clear cut, certainly not a slam dunk by any stretch, and would appeal to the court's discretion here to allow the default to open and allow a defensive posture to come into the case. I want to be careful, Your Honor, we're an unnamed defendant and we're a UM carrier, and I don't want to do anything improper in terms of discussing collateral source issues in the case. So I'm not going to, but what I do want to say is that, I think there's large leaps in logic and understanding to say, okay, look, we're the plaintiff's undone. The plaintiff's not happy about this. The plaintiff doesn't buy what JMP is selling, and therefore the entire case is going to be unfair and discovery is not going to be truthful, etc. I think that's a far cry, especially when defense counsel is involved in the case and you've got officers of the court that are going to be the gateways for discovery materials. So I just would argue that there is zero prejudice to the plaintiff in this case if the matter is opened. And in fact, would submit that it is entirely beneficial to the plaintiff if the default is set aside and it's opened and an answer can be filed. That's our position.
Okay. Anything further from anyone?
No, Your Honor, not from plaintiff, Your Honor.
All right. Well, thank you, gentlemen, for your patience. And we'll get an order filed in the next few days. Thank you.
Thank you.
Have a good day.
Thank you. I'm assuming we can be excused.
Yes.